The Appellate Division, First Department, is now in session. Good morning and welcome to the Appellate Division, First Department's virtual oral argument. I will now call the calendar. People versus Armin, submitted. Palomino versus Paradise Pacific, submitted. Matter of T Children, submitted. Miller versus Levanis, submitted. Delino versus Puelo, submitted. People versus Nieves, submitted. Kahn-Friedman versus Cadis Corporation, submitted. Lumbermen's Mutual versus AB Medical, submitted. Giddy versus 400 Great Neck. Appellant?
Good morning, Nicole Galetta for the appellant.
You have 5 minutes. Respondent?
Good morning, Brian Vanella for the respondent.
You have 5 minutes also. People versus Reyes?
Yes, good morning, Your Honor. Alma Gonzalez for appellant, Mr. Reyes.
You have 4 minutes and 1 for response.
Thank you, Your Honor.
Respondent?
Good morning, Julia Chariot for the people.
You have 5 minutes. Matter of Toussaint E. submitted. Hisiano versus Tremont Electric submitted. People versus Buskis.
Good morning, Jan House for appellant Debbie Buskis.
You have 5 minutes and 1 for response.
Good morning, ADA Noah Shamway for the people.
You have 4 minutes. Metropolitan Bank versus Lannon.
Good morning, Brandon Sherman for the appellant.
3 minutes.
Tom Mulaney for respondent.
You have 3 minutes. Liu versus Room Holdings.
Good morning, Your Honor. George Wang for appellant Ruhan.
You have 8 minutes and 2 for response.
Your Honor, Justice Friedman, this is Scott Musoff for the underwriter defendants. We were given 2 minutes for argument. I think it was 8 for one appellant and 2 for.
That's correct. Thank you.
Yeah, Your Honor, if I could have 6 for opening and 2 for response, that would be great for me. George Wang for defendant Ruhan.
You want, instead of the 8, you want 6 and 2.
That would be terrific.
Fine. Respondent?
Good morning. This is William Geddes, and with me is my colleague Joseph Daly, who's been admitted pro hoc vice to this court. We respectfully request permission for him to participate in this appeal.
Okay, that's granted. You have 7 minutes.
Thank you.
Creer versus City of New York is submitted. Yaruso versus NYPD.
Thomas Tordo for the appellant.
You have 4 minutes and 1 for response.
Thank you, Your Honor.
Jonathan Popolo for respondents.
You have 5 minutes. People versus LaFontaine.
Good morning, Your Honor. Danielle Krumholtz for Mr. LaFontaine.
You have 2 minutes.
Morning, Your Honor. Michael Yetter for the people.
You have 2 minutes. Savarowski versus 228 Thompson is submitted. Hernandez versus 5Js is submitted. Lipson versus Herman.
Good morning, Your Honor. John Golashevsky on behalf of the appellants.
You have 2 minutes.
Thank you.
I take it there's no respondent appearing. Admiral Indemnity versus Johnson is submitted. I remind the attorneys to keep their microphones muted until their case is called for argument. I also remind the attorneys to avoid speaking over the justices when the justices are speaking. This is a traditional rule of the court, and it's even more important when we're doing the virtual argument. First case for argument, Giddy versus 400 Great Neck. Please proceed.
Good morning. May it please the court, Nicole Galetta for appellant Nicolias LLC. May I reserve 1 minute for response?
Yes.
Thank you. The plaintiff's motion for summary judgment in this case on his Labor Law 240 claim was erroneously granted because there are remaining questions of fact with respect to whether or not the plaintiff was acting outside of the scope of his employment at the time of the alleged accident. In our underlying opposition, we submitted evidence.
Counsel, isn't the only evidence that you present, the so-called, isn't the only document that you present to support that claim the unsigned letter from Mr. Shakur, which doesn't even have a signature on it. It only has a typed name, correct?
That is correct.
And no there's no explanation of where that letter came from or anyone who observed it being written or signed or submitted or no, I didn't see, unless I missed them, were there any other indicia of reliability concerning that document?
We don't have an affidavit from anybody who saw the letter being written. We did submit the affidavit.
Reliability.
I'm sorry, you broke up for a second.
Are there any indicia of reliability in the record?
Well, what we submitted was an affidavit from an investigator who attempted to procure.
I understand he tried to find Mr. Shakur, but are there any indicia that this document in itself has anything to do with Mr. Shakur?
Only the document itself.
Okay.
But
Counsel, I was going to ask you, even if, and that's a strong if, I thought that there was some reliability to Mr. Shakur's affidavit. What he said in that affidavit was that Mr. Gidi was returning, he had gone up to the roof to return something he thought had fallen. So how is that outside the work he was doing, even if I were to, to give the reliability to this affidavit?
Sure. Well, the work that the plaintiff was assigned to do on the date of the accident was to work on the ground as part of the support team. He was not assigned to return materials that he thought were fallen, even if that was the case, to the roof.
But wasn't he cleaning up? I mean, wasn't that what he was?
He was cleaning up the ground. He was not assigned to clean up the roof.
I mean, you think that if something falls off the roof and someone working there and is assigned to work there returns it to the roof, that's outside the scope of his employment? Is the scope of employment so rigidly defined?
Well, for the purposes of Labor Law 240, I think that it is. The statute.
I mean, no one told him don't go up to the roof to return an object which falls down.
Well, we only know that he was told he was assigned to work on the ground. He was not assigned to work on the roof. Labor Law.
In the letter, Mr. Shakur didn't say, despite my telling him not to go to the roof, or even though he was assigned to work only on the ground. There's nothing in the letter that indicates that that was outside the scope of his work, correct?
Well, I don't think outside the scope of the work requires a showing that he was told not to do something. It requires a showing that he did something that he was not specifically told to do. So we don't have to show that he was specifically prohibited from going to the roof. We only need to show that he was only authorized to work on the ground, which I believe that we did.
Do my colleagues have any further questions? Thank you. Respondent.
Good morning, Your Honors. May it please the court. I think based on the questions that Your Honors have been asking, that you understand the crux of respondent's argument. Just to respond to a few things that Ms. Galletta said, in this letter that was purportedly prepared by Mr. Shakur, the scope of the work of the ground team is not defined in any specific way. So the argument that Mr. Gidi was working outside the scope of his work is really an assumption, even assuming that this court were to consider this letter as admissible evidence. In fact, in this letter, it states that instructions were given, and one of the things that instructions were given as to is in the direction in which we would be relaying the equipment from the ground to the roof, which indicates that equipment was being brought from the ground to the roof, which is precisely what the letter states Mr. Gidi was doing at the time of the accident. Obviously, defendant appellant does not disagree with the Supreme Court decision that plaintiff established a prima facie entitlement to summary judgment. That wasn't a part of their appeal. They simply argue that the unsigned and an unsworn letter purportedly written by Mr. Shakur raises a triable issue of fact, and that depends on assumptions that are not in a plain reading of this letter. To go back, it's plaintiff respondent's position that this letter is not admissible in the first place. This court has stated in the past that even though hearsay evidence can be considered in opposition by a non-moving party, it can't be the only evidence to defeat a motion for summary judgment. Here, this is the only evidence. In addition, to consider something that is not submitted in admissible form, the party seeking to have that document considered needs to set forth a reasonable excuse why it could not be submitted in admissible form. Here, the defendant appellant simply did not do that. They sent an investigator out 1 week before opposition to the motion for summary judgment was due to be filed, nearly 3 months after plaintiff filed his motion, 4 years after the accident, and 3 years after defendant appellant appeared in this case. There's no evidence of how it came. The only evidence that Mr. Shakur prepared this letter is that his name is typed at the bottom. And simply put, anybody with a word processor could have prepared this document. It's addressed to someone by the name of Joseph Garino. Mr. Garino offered no testimony in this case. There was no attempt to contact Mr. Garino to see, for at least him to testify that Mr. Shakur provided him with this letter and the circumstances surrounding it. Defendant appellant really did not meet any sort of burden to show a good excuse, which is what the Court of Appeals requires for the consideration of evidence not submitted in admissible form.
Do any of my colleagues have any further questions? Thank you. Thank you, Mr. Bonella. Ms. Scaletta?
Thank you. I would just note that in terms of an excuse, we did submit an affidavit of an investigator who went to locate Mr. Shakur, who was unable to procure an affidavit from him. And some of the questions that Mr. Bonella raised
So how does that get us to accept an unsigned statement?
Well, the court has repeatedly held that evidence that might otherwise be considered hearsay is admissible for the very limited purpose of opposing a motion for summary judgment where the offering party offers an excuse as to why they could not produce the evidence in admissible form. We've done that here.
Any other questions for counsel? Thank you. Thank you both.
Thank you.
Thank you, Your Honors.
People versus Reyes.
Yes, good morning, Your Honor, and may it please the court, Alma Gonzalez for appellant Mr. Reyes. May I proceed, Your Honor?
Go ahead.
Thank you. I'd like to get directly to the serious physical injury issue because it's at the center of this case. And if later time permits, I'd also like to address the excessive sentence point. Going to serious physical injury, protracted injury was not shown here beyond a reasonable doubt.
Ms. Gonzalez, at the time of the trial, which I think was approximately 2 years after this incident, didn't the victim testify about the severe bruises that are still having a lot of pain in his eye, and there was a serious injury to the orbital lobe? I mean, there was a pretty serious injury there. I don't know how you can say that wasn't. He was still having trouble at the time of trial. I recall in looking at the testimony.
He did testify to that, Your Honor. However, from the post-surgery records that we have here, those records indicate that his visual acuity was intact after the surgery. And in fact, the records that were produced were based off of what the complaining witness here was claiming that he was experiencing or not experiencing at the time. So we really do have a conflict here between what his state was after surgery and what the complaining witness then claimed to be experiencing at trial. And notably, there are no records or any evidence going to what he was experiencing between the time of surgery or the end of surgery and trial. Notably as well, even in the complaining witness's testimony, he never alleged that he went to any follow-up appointments during this 2-year period, or that he felt any other issue. As far as the records show, the surgery actually repaired the injury here, and that it did repair the orbital floor fracture, and it did reinstate his visual acuity. And so for those reasons, there really is an issue here as to whether protracted injury was proven. We do have medical records that lean against what the defendant, what Mr. Martinez was testifying to, and that really also goes to the issue of causation, Your Honor. What respondent offered here as proof was testimony by a medical expert as to what could have been the cause of the symptoms that Mr. Martinez was alleging at trial. And there are numerous issues with that testimony, Your Honor, beginning with the fact that
didn't they have to emplace a plate in the eye socket and use 2 screws?
Correct, Your Honor. Yes, and that did repair the fracture in this case.
But that's a continuing condition, isn't it? I mean, it's not something that was done and it was taken out and now everything is back as the victim was originally.
According to case law, Your Honor, that would not be considered protracted injury because it did repair the injury in that case, and we did cite
a person being left with a plate and screws in his eye socket, which I mean, if he looks down, there's some effect upon his vision, isn't there? That's not serious injury.
Well, Your Honor, the plate in this case was actually a resorbable mesh plate, and so the resorbable mesh would actually absorb into his skin. It's not like a steel metal plate, for example. And because we don't have any evidence of what occurred between surgery and trial, we also don't know whether the screws were ever taken out of Mr. Martinez's eye socket. And I'd like to return quickly to just the expert testimony in this case. The expert that was offered was an expert in internal medicine, not a vision expert that could have actually given a valid opinion as to what would be the cause for the injury in this case. And indeed, that medical expert actually had to refer Mr. Martinez to an ophthalmologist for follow-up. And this expert was not the person who actually did the eye surgery in this case. What we have here is merely just a probable connection between the altercation and Mr. Martinez's injury.
Any further questions for counsel? Thank you. Respondent.
Good morning. May it please the court. Your Honors, the defendant's guilt of first-degree assault was completely supported by the evidence here. He, as a result of the defendant kicking him in the head twice, and this is after.
I have a question. Was there any challenge to the by the defense to the qualifications of the people's medical expert to testify on this subject?
No, there wasn't, Your Honor. And to the extent that counsel is arguing that she wasn't an ophthalmologist, to say that a medical doctor is incapable of providing testimony about an eye is absurd. Simply to say that because she can't perform ophthalmologic surgery doesn't render her incapable or render her unable to speak about the eye or render her knowledge gained through years of medical school invalid in this case. And, along those lines, counsel calls upon this court to make vast amounts of speculation based on, this concept that there was a notation after the surgery that visual acuity was intact. I submit to this court that, without any description of the tests, there's no notation that the diplopia or the double vision was resolved. It simply says that he wasn't blinded by the surgery where they removed his eyeball from its socket. And again,
did he testify at trial that he was still having problems with his eye?
Absolutely. Mr. Martinez testified extensively about his injuries. He was still experiencing double vision. He was having difficulty running. He was getting redness in his eyes. It was severe, ongoing.
And he also testified that he never had any eye problems prior to this incident. Isn't that correct?
I believe, yes, that this was all a result of the incident. And, to suggest that somehow that the causation is not from the incident it's beyond reason, Your Honor, because to suggest that somehow he had sustained the severe injury, that he continued to suffer the repercussions of it, yet somehow this court should speculate that another intervening cause somehow existed, which is what counsel is asking this court to do.
Before your time runs out, because I assume that Ms. Gonzalez is going to address the issue. You want to address the sentence issue?
Certainly. This defendant received 7 years. That is a mere 2 years above the minimum. To say that it is an excessive sentence is, in light of all the severe injury that was testified to, is absurd. Again, this is just not the most lenient sentence. And this court can look at all the factors that all the factors that's been cited were considered by the sentencing court. There's no reason to disturb that sentence at all.
Any other questions for counsel? Thank you.
Thank you.
Ms. Gonzalez.
Yes, I'd just quickly like to respond to the expert testimony again. In addition to, again, this is not someone who is skilled or trained in vision or eye care, and so
are you saying that doctors are not trained that a doctor is not trained during medical school to understand the workings of the eye?
No, Your Honor, I'm not.
Ophthalmologists understand eyes?
No, Your Honor, I'm not arguing that. What I'm arguing is that in order to make an expert determination about causation here, this expert or so-called expert would have at least needed one to have had records post-surgery, because this expert only
challenged at the time on that basis.
No, Your Honor. No, it was
so,
not.
I mean, this wouldn't go to like the admissibility. It would just go to the weight, and the jury. I'm sure your attorney had the opportunity to question the doctor about that, and the jury had an opportunity to evaluate whether, what kind of experience they had. So I think it's late to raise that at this point.
Correct, Your Honor. But I'd also quickly like to point that the prosecutor did tailor the hypothetical to include the facts concerning the altercation here, and the Second Department last week in Shane found that exceeds the permissible bounds of expert testimony. And to just quickly address the excessive sentence point here, that we're only asking here for a 2-year reduction. Mr. Reyes, I think by the briefing, has shown that he is a truly valued member of his community. He is facing imminent deportation, and what was not before.
Excuse me. The testimony showed that he kicked the victim with his construction boot after the victim was already on the ground, right?
Yes, Your Honor. However, Mr. Reyes did express deep remorse in this case, which was noted by the sentencing court. He expressed this remorse not only at sentencing, but also even in his trial testimony. And further, Your Honor, Mr. Reyes is the provider for a lot of different people, a total of 10 people, 2 of those people being his 2 young daughters, one of which has a multitude of medical health issues, and he also provides for his brother who is a paranoid schizophrenic. Mr. Reyes was also a valued employer among his communities. He was employing about 25 people at any one time. So those employees and their families have also lost income because of this. And we do submit that because of his deep remorse in this case, and this also being his first offense, 7 years is unduly harsh, and would only prolong his inevitable deportation and his conviction for this.
Any further questions for counsel? Ms. Gonzalez, you're awaiting admission?
Oh no, I've been admitted, thankfully, in June.
Because I see that's what the brief says. Good luck. Thank you both. People versus Busketh.
Good morning, Your Honors. Jan Hoth for Appellant Debbie Busketh. Mere presence at the scene of a crime or association with a person who commits a crime is insufficient to establish one's criminal liability for that crime.
Counsel, this is Judge Kern. Isn't there also evidence in the record, though, that she actually participated in the crime by stabbing the victim, which the jury could have found was sufficient evidence?
That's actually the weakest evidence in the case, as even the trial court noted in denying counsel's motion to dismiss. It was basically based on the evidence against her father, against whom all charges were ultimately dismissed. The only evidence presented at this trial showed that my client was there. None of the witnesses saw her in possession of a knife. None of the witnesses saw her.
Counsel, what about the video footage which showed her right behind the victim, and then the victim put his hand to his back and found blood when she had been right behind him in the video footage? Isn't that some evidence that she was the one who used the knife?
The only testimony that she was there, and I'm sorry, it wasn't even testimony. The only person who said that was her and thrusting her arm at Mr. Smith's knife was the district attorney. The court said that all it could see was people's feet, and the quality of this video was so bad it precluded any of the witnesses from identifying appellant as being in it. So
But the jury saw the videotape and they also saw your client. And wasn't she the only person in the video with a ponytail?
Yes, we don't dispute that Miss Busketh was on the scene. There was...
And didn't that video also show her right behind the victim, right before he started bleeding?
Well, again, she was standing on the scene. She was in proximity to him. He then ran away, grabbed his back. There were other people there. There were a lot of people there. The point being that, is this sufficient to establish somebody's guilt beyond a reasonable doubt? And we say that it's not. She was there. We concede she was there. But we have
Who do you suggest did the stabbing if it wasn't Smith? I mean, Nowran did the shooting. Isn't that so?
No, there was no shooting, Your Honor. Nowran was originally accused of stabbing Mr. Smith in the belly. And then he also...
Tell me something. Aren't Lokai and Persad shot?
Well, they were shot by Miss Busketh's brother, who was tried with her, but he's not subject to this appeal. Miss Busketh was charged with either stabbing Mr. Smith in the back or acting in concert with her father to stab him in the belly. And the charges against her father were dismissed following this trial because the district attorney decided that Mr. Smith, who had made representations to the grand jury as to Nowran's involvement in this, and then retracted them and told the petty jury that he lied to the grand jury, they now decided they wouldn't be able to get a conviction against Nowran, but nevertheless, they are fighting to keep this conviction against Miss Busketh, against whom the evidence is so much weaker than against Nowran. And before my time is out, I would also like to address the question of physical injury. Again, as I just pointed out, Mr. Smith is an admitted perjurer. He either lied to the grand jury about Nowran's involvement or he lied to the petty jury about him not being involved. He claimed that he saw a knife. It was 2.5 inches. Now then at trial, he claims he lied. Yet his is the only testimony we have that he suffered substantial pain. And he doesn't even claim it was substantial pain. He said it hurt a little. And his claim that he got pain medication is belied by the medical records. And even the doctor at trial said if he had been complaining about pain, he would have been given pain medication. He rated his pain as a 0 out of 10. That's not even minor pain. That's no pain at all. So there's no evidence that
does it seem, are we supposed to believe that someone who received a laceration by a knife in 2 parts of his body suffered no pain? Is that what you're asking us to accept?
Yes, because that's what he said. In the hospital, when he had no reason to lie, when you want to be treated for the injuries that you're suffering from, you would not lie to the doctor and say, I'm suffering no pain. You would say, it hurts. I mean, it just makes common sense. Now, at trial, he's saying it, and even at trial, he only said it hurt a little for a day or 2.
But doesn't that same common sense tell us that someone who has suffered 2 knife wounds, even if they weren't serious knife wounds, is suffering pain?
Your Honor, I thankfully can say that I have never suffered a knife wound, so I do not know. All we have to go by is what Mr. Smith himself testified to, and at best he said a little pain for a couple of days. Anything that the hospital did, they did as preventative medication. They stapled the wounds not because there was any evidence that he would have suffered had they not. They said to promote rapid healing. They did a CAT scan preventatively. And Ms. Buskis should not be penalized because we now have advanced medicine, which doctors are under a duty to perform all tests and make sure that there's no underlying problem.
Any other questions for counsel? Thank you. Respondent?
May it please the court, Noah Shamoy for the people. Your Honor, I'm going to briefly correct the record. Basically, the medical records themselves, as far as physical injury, in fact, pages 7, 28, and 32 of the medical records reflect on 3 different times he reported suffering pain to the medical personnel. It is, in fact, one notation later in the medical records that my adversary is speaking about, where it is potentially after he received a painkiller, though that's contested, that he then said he was in no pain. Again, so we have 3 different times in the medical records where he reported pain to 3 different individuals. In addition, at the trial, the testimony that he actually said was that he was in a lot of pain. That is the quote from page 223 of the record. The comment that my adversary is speaking of when she said he hurt a little was actually in reference to how many days of pain he had, which is on page 138 of the record, and he said he needed a painkiller, which would explain why his pain was less. So those are the pages of the records that reflect that he actually was in pain subjectively. Objectively, as Your Honor pointed out, it is pretty clear that he would have suffered pain given that he had 2 stab wounds, not lacerations, stab wounds, where he was punctured by 2 different knives by 2 different people. In terms of mere presence, I also need to correct the record. The trial court found the evidence overwhelming. It called it strong and decidedly compelling evidence of guilt, and it said that the people proved defendant was no mere bystander. She shared her father's intent to cause the physical injury by stabbing him herself at almost the same moment her father inflicted the other stab wound. And repeatedly throughout his decision, the judge pointed out that she was tried as a principal and could be convicted as a principal solely on the evidence that she stabbed him in the back. The video evidence in this case is overwhelming, actually. It shows her approach him, the victim, while her father's tussling with him and fighting from the front. It shows her pull her right hand out of her pocket, and it shows her swinging that arm towards the victim's back right before he pushes away from the father, runs into the street, which is when he says he reached to his back, took his hand out, and saw that it was covered in blood. So this is an overwhelming case of principal liability and accomplice liability for both stab wounds. If you have no further questions.
Any questions for counsel? Thank you.
Thank you.
Ms. Huss?
Yes, I won't belabor the point. I think everything's been covered, but I would just like to reiterate that the video evidence here was far from overwhelming. It was the district attorney admitted that the video was of poor quality. The court said it was of poor quality. The court even said all it could see at the alleged time of the stabbing was people's feet. The only person who claimed they could see Miss Buzzkiss swinging her arm at Mr. Smith's back was the district attorney. That is not evidence beyond a reasonable doubt of her guilt. Thank you.
Thank you. Thank you both. Metropolitan Bank versus Lannon.
Good morning, Your Honor. May I reserve 1 minute for response?
Yes.
Thank you. May it please the court, I want to emphasize at the outset that this is not a business dispute. This is a case about embezzlement and whether the daughter of someone who embezzled $30 million from a bank in the Philippines can keep money and property representing the proceeds of that embezzlement.
Does your complaint allege that Ms. Lannon knew about what was happening?
It does. And the only thing that we don't know at this stage is exactly when she knew and when she knew it and what she knew. At some point in 2017, Ms. Lannon's mother is arrested in the Philippines, and immediately upon that event, her father transfers his entire interest in the condominium to Ms. Lannon. Ms. Lannon lists the apartment for sale, goes to contract on the sale, and the only thing that stopped the sale from going forward was this action. So, you know, I think it's pretty clear that you know when your mother gets arrested, but there's also a lot of smoke here in terms of what she knew before that. This is someone who was making the equivalent of, in US dollars, $30,000 a year in the Philippines, and at some point, she buys an apartment in Manhattan for her daughter worth $1.5 million. She buys a house in Las Vegas, also for her daughter, worth about $600,000. And she's bestowing other properties on her other children, her sister-in-law in California, in Texas. And we believe there's cause to think that there's other property in the state of New York in Ms. Lannon's possession that also represents ill-gotten gains of the embezzlement. There's
and can I? Is this enough? Are these facts enough to for a cause of action for the imposition of a constructive trust? I mean, that's that's another cause of action or another.
They are, and I think that's the critical cause of action. And this court has held since Simons that a constructive trust is an extremely broad remedy, and the language is quite colorful. That it exists to give effect to whatever human imagination might do to take property from one person to another. And it exists as a remedy when someone receives property under terms that are unjust. And that's exactly what's happened here.
Does the notion that if you've made out unjust enrichment, that sort of is supportive of the constructive trust cause of action too?
That's exactly right. It's one of the elements, and especially where you're not looking to the sharp factors, what this court has held is you can make out an unjust enrichment claim when there's property at issue, and there's unjust enrichment, and that property is received under circumstances that render.
This is Judge Kern. What's your response to that the relationship is too attenuated to support an unjust enrichment claim?
So I think there are 2 points on that. Number one, it's not required under Simons. Simons expressly says that the constructive trust doctrine exists regardless of whether there's a confidential or fiduciary relationship. And this court affirmed that most recently in the Robinson case. Actually, I don't know if it was most recently in the Robinson case, but it was certainly in the Robinson case where it says you don't need to plead this special relationship. The other thing that this court has held, which is on point here, is that this is a fraudulent scheme in which the respondent knows that she's participating on some level, certainly over the last 3 years, but as we alleged before that, and remember, we're at the motion to dismiss stage, so that allegation should be accepted as true, that she knew what she was doing. And that is a sufficient allegation, even if there's no close relationship. If you have someone who is a participant in a fraudulent scheme and knows that what they're doing is essential to the scheme, that scheme being to take money from the bank, bring it into the United States, and prevent the bank from asserting any kind of claim to it because it's not the person who stole the money, at the point where she knows she's participating in that scheme, it doesn't matter what her relationship to the bank is. That's enough for a constructive.
It's certainly a subject for discovery.
Exactly.
And is it your assertion that part of the scheme is the transformation of the cash in the Philippines into a different asset in the United States, that that's an integral part of the scheme, that it's not only the embezzlement, but also then the transfer of the property out of the Philippines into the United States and the transformation into another form?
That's
part of the entire scheme. So that's a part, from your viewpoint, is that part of the scheme?
That is part of the scheme, yes. But certainly, I'm sorry, go ahead.
No. Finish your thought.
The part of the scheme that we think Ms. Lennon has the most culpability in terms of is attempting to sell the apartment when she now knows that there's been this massive embezzlement and there's no other explanation for the source of the funds.
Any other questions for counsel? Thank you. Respondent.
Thank you, Your Honor. First of all, in the complaint against Ms. Lannon, there is no claim of fraud or aiding and abetting fraud or aiding and abetting fiduciary duty. Ms. Lannon was 12 years old when this alleged scheme started.
But counsel, isn't the allegation not that she participated in the formation of the scheme when she was 12 years old, but that she participated in the completion of the scheme when she was a young adult by accepting money which she knew was tainted, participating in it being transformed into a real asset, and then participated in transforming it back into sort of cleansed cash? So at that point, she wasn't 12 years old. Isn't that, as I understand the scheme, it's not just the stealing of the money, but the transformation of it into a different asset overseas?
Well, that Ms. Lannon is accused. What's in the complaint is that Ms. Lannon received property from her father, not cash from her mother. There's no evidence that she was the counterparty to any of the cashier checks, letter, financial instrument counterparties. Those were different people in different places. She got funds from her father. What his income is.
Which she is alleged to have known or had reason to know that the property that was being purchased was purchased with the proceeds of Marivik's criminal activity.
That upon information, it is alleged, upon information and belief that she knew or had reason to know. That is, I don't think that would suffice if there were actually a fraud claim in the complaint, and there is not one. But there are. What there are
suffice for unjust enrichment, perhaps, or constructive trust.
Well,
we're not talking about a fraud cause of action.
That's right, we're not. But what we are talking about, if we want to talk about constructive trust and unjust enrichment, are claims that require some relationship to the entity that has been allegedly defrauded or had their property converted. Here, there is no relationship whatsoever, none. And so what the appellant is asking the court to do is to disregard all of the sharp factors and have the constructive trust doctrine cover I know it when I see it, as Justice Potter Stewart said, and that is not does not comport with the law of constructive trust. All of the cases require some connection.
But it's not necessarily required for unjust enrichment. And under your theory of unjust enrichment, if the person who had the relationship with the person they were stealing from moved the money fast enough, and if the person to whom they were transferring it shut their eyes tightly enough to the source of the money, then it could never be recovered. Is that really what you're arguing?
That is not what I'm arguing, Your Honor, and that is the fallacy of the appellant's point, is that if these claims, which are not the proper claims, If these claims are denied, then there is no way, there's no remedy, and that is not accurate. What the bank could do, and I don't understand what the problem with this is, because it's 3 years after this allegedly flagrant scheme was uncovered, is take the judgment from the Philippines and go to court. I see Justice Gesmer shaking her head. Those are the remedies for enforcement of a foreign judgment. There also could be debtor and creditor claims. Those weren't brought. What we have
it seems like what you're contending to reduce it to a very simple level of A steals money and gives it to B, and B gives the money to C, and C knows that B received the money from A and that it was stolen. A doesn't have any claim against C. That's what you're saying.
No, what I'm saying, Your Honor, is that the allegations here don't support that hypothetical. All we know is that Miss Lannon got funds from her father. There is no connection.
That she had reason to know was coming from criminal activity. And information and belief was coming from criminal activity.
I mean, it's just, the problem is it's a motion to dismiss, and a lot of these things, the plaintiff is not in a position to know all the details at this level. That's why you have discovery in cases and you flesh the allegations out. But they've at least made allegations that have some sense in some basis for us to perhaps, think that there's some validity to them.
Well, there may be some allegations that could have been brought, but these allegations require a relationship, and I would disagree with what Justice Gesmer said. The law of unjust enrichment requires all relationship that be not too attenuated. It is not dissimilar from constructive trust. Here there is no relationship, none. Miss Lannon didn't have an account at that bank. She didn't even live in the Philippines. She was a child for most of that time.
Counsel, isn't her relationship to the bank that she's the daughter of the person who embezzled from the bank? And she's the person who benefited from the embezzlement of the bank by the means of the money being transferred from her mother to her father to her. Isn't that a form of relationship? It's not a friendly relationship, but it's certainly a relationship.
That is not a relationship to the bank. There's nothing that is in any of the case law that suggests that. And if that were the relationship, then there'd always be a relationship. Because at some level, someone who is alleged to have received money 3, 4, 10, 20 degrees separated, there was always some relationship.
But of course, that's not the situation here.
Well, the situation here is that a child was supposed to know. There's no allegation that she knew what her mother's income was.
Well, she's not a child now. I mean, she's not
a child now
anymore.
That's right. So what I guess the crux of the claims are that she attempted to sell this property when she may have had very good reasons to need money. Her property has been tied up for 3 years now without any hearing whatsoever. It has been attached without any due process, and money that perhaps she was going to borrow money to pay for her lawyers, or perhaps her father said, I'm going to need money. A lot of things are consistent with innocence as well as consistent with sort of a reverse engineered claim, which is the daughter must have known something or done something wrong because her mother didn't have a job that paid a lot of money. We don't know what the father...
So I suppose, in making this argument about it being too attenuated, I suppose it involves Georgia Malone. But in Georgia Malone, you were dealing with a party who was a good faith purchaser for value. You don't really have that type of an allegation here.
Well, as a matter of fact, the Georgia Malone case involved a company that purchased due diligence materials that have someone else's name all over them. So that is not quite an analogy.
But the Court of Appeals did use the phrase good faith purchaser for value.
It did use that phrase, but it also made a point of noting that the purchaser of the due diligence materials saw that they had been drafted by somebody else. Here, if Miss Lannon's apartment had on the deed Metropolitan Bank, it's a corporate apartment from Metropolitan Bank, and that got whited out, and her mom said, here, the bank wants you to have this apartment. That would be some evidence that she knew that this the apartment coming to her did not belong to her mother.
I just want to turn, you're way past your time, but I want to turn your attention to one other. What in your view supports striking the conversion cause of action?
Well, conversion requires a specifically identifiable piece of property, or if it's cash, money. Here, the property is an apartment, and conversion is not, nobody's alleging that the apartment itself was physically stolen. Using the deed example, didn't belong to the bank before Ms. Lannon came into her ownership. Two, if there is a specifically identifiable fund of money, that can be subject to conversion claim. That is not the case here. What could have been a conversion claim would be if one of those cashier's checks or a wire transfer on a certain date in a certain amount went to Ms. Lannon, or even went to her father and then went to Ms. Lannon. That could be the source of a conversion claim. Here, the bank says over some period of time, over the 16 years, 17.5 or $31 million was embezzled. Some of that must have gone to Ms. Lannon, and Ms. Lannon therefore is liable for conversion. In fact, they don't identify that any cash at all went to her, only that the property went to her. And so the conversion claim doesn't even specify one single dollar that went to Ms. Lannon.
Thank you. Any other questions for counsel? Thank you.
Thank you, Your Honors.
Mr. Sherman?
Very briefly, picking up on the conversion point, I think this is it's sort of the same approach that respondent is taking with the constructive trust claim, trying to put us between a rock and a hard place. We cannot identify the money before there's discovery. We know that $30 million was taken from the bank. $2 million was transferred in money and in the form of properties in New York and Las Vegas to Ms. Lannon, and a substantial part of it is still missing. There is strong reason to believe that Ms. Lannon has this money, and I would point only to her conduct in discovery of this case, which, despite 2 or 3 orders for discovery to go forward, continually resisting any form of document production, depositions, moving to quash subpoenas. There is a lot of smoke here, and at the pleading stage, all we need to allege is a good faith basis to believe she has this money. We do not need to produce specific checks or evidence of wire transfers or anything of that nature in order to sustain the claim at this stage. There is strong reason to believe, based on what we already know she has based on public records and what remains missing, that she is sitting on a lot of this embezzled money. And you need to look no further than her resistance to doing any form of disclosure in this case to support that. There's a lot to that.
Any other questions for counsel? Thank you both. Liu versus Rune Holdings.
Good morning, Your Honor. George Wang, Simpson Thatcher for defendant Ruhan. This case revolves around plaintiff's allegations of misstatements revolve around a single number in Ruhan's IPO disclosures. And that number is that there was 91 full-service online stores as of December 31st, 2018. But
Mr. Wang, didn't plaintiff allege a few other pieces of information that in addition to that 91 number, as to the number of its signed KOLs from at that time, and also claim that you failed to disclose about the net revenue? So there were a few other claims other than just that one number, wasn't there?
That's correct. The court below really only addressed the first claim, but the complaint does address all 3 of those complaints, and I can address them as a basket. Plaintiff's basic theory is that These numbers, Ruhan reported these numbers as of December 31st, 2018. And plaintiffs don't contend that they reported the numbers wrongly as of that date. What they contend is that you should have reported another quarter. You should have reported the March 31st, 2019 quarter in your IPO documents that were filed, that went live on, they were filed initially in March, but it went live on April the 3rd. And their contention is, look, they understand the SEC doesn't require you, it's too recent to put out all of the financials, but their argument is that this information was such a significant contraction, so important that you should have gone out of your way to pinpoint and flag to the market these pieces of information. And the premise of that argument is that there was a substantial contraction in the full service online, full service business, both online stores and KOLs. But that premise is demonstrably false from the record, right? Because if you look at the sales from this full service online, full service unit, sales went up in this quarter, in the March 31st quarter. Sales from the full service unit in particular went up. That's in the record. Sales from the companion business, the platform business went up, and overall sales went up. So
well, but can I ask you what part does it play that plaintiff claims that the value of their ADS or of their $125 million investment in shares went down approximately 73% within the first few months of their purchase of this very large of these shares? And shouldn't they have at least, I mean, shouldn't they have decided whether or not that was a material issue that they should have known about?
Yeah, but there's no connection between the two, right? So there's been a lot of, if you look at all Chinese companies, they've gone down a lot in stock value over this time period because of China-U.S. relationships. So the fact is that when this information was disclosed, the fact that the KOLs had dropped, the full service online stores had dropped, the Ruhan stock price went up. When the quarterly financials for March 31st were out, Ruhan stock went up. Ruhan would have liked to have put all this information in to the prospectus, but it just wasn't available at that time, right? And that the key fact here
Counsel,
is
this is Judge Kern. I understand your primary argument is that you expected, you fully disclosed that you were shifting to a platform model and that any investor would have known that. But I guess my question is, didn't you have to explicitly disclose in your materials that you consciously expected to substantially reduce your full service model, which you in effect did in that interim period by reducing the number of stores? Wasn't there some obligation to say not only that we expect to increase the platform model, but we expect to decrease the full service model? But we didn't decrease the full service model, right? There were fewer stores, but we sold more from those fewer stores. But didn't you consciously take away, I'm forgetting the name, the influencers consciously took influencers from the full service model, moved them over to the platform model with the intention to, and reduce the number of things being sold on the full platform model, which was a conscious decision to say, we are going to reduce the role of the full service stores, not just increase the role of the platform model. Yeah, but there's two separate things. Yes, the number of full service online stores went down. Yes, the number of full service KOLs went down. But no, that the number of the sales from the full service model, it actually went up in that quarter. It still went up despite the drop in stores and KOLs. Once you decide,
once you took it upon yourself and you had to make these statements about what was going on, shouldn't you, so as the investors had a full view of what was going on, did you have some obligation to let them know that you were doing these? Not they should just assume from what you were doing, but that you had already done it, even if it wasn't a formal fourth quarter statement, to let them know this. And isn't it premature to say that this was not material to them? How do you know it wasn't material to them? Maybe it would have been material to their determination to purchase the shares.
Right, but the key fact here is that sales from this business line, the full service business line, went up in this quarter, despite reducing the stores, despite reducing the KOLs. So let me offer a quick analogy. Let's say I was an ice cream store. I had 91 flavors. I sold 91 flavors. I cut back to 56. Right? So that's a reduction. But if I cut back like the low sellers and I keep like my best sellers and my ice cream sales go up, and while I do that, I expand like Ruhan did with his platform business, it opened 100 new platform stores in this same quarter, right? So you opened, like you introduced like 100 new froyo and sorbet flavors. Look, is the composition all that significant? What matters is, do your ice cream sales go up? Yes, in my analogy, full service sales went up. Fewer flavors, fewer online stores, but the sales went up because most of Ruhan's sales, well, a majority of their sales.
Is your point that overall your disclosures were accurate?
Exactly. That's exactly right. And Ruhan would have liked to have put out all of its first quarter financials, because the punchline was that sales went up, revenues went up, profits went up, and that's why the market reacted favorably when it put it out. But it just, this is 2 days into the next quarter. It wasn't able to put out that information, and it didn't want to selectively put out information, because then the allegation would be, you pick and choose what you like.
Thanks. Any other question? Yeah.
That was my next question, was, since your prospectus was going out early, a few days into April, you clearly couldn't put out all of the data for the first quarter. And if you had put out only the decrease in the number of stores, that you might have been accused of being selective about what information you were providing, and that would have been a further violation of your obligations.
Exactly, right? So the decrease in the number of online stores and decrease of the number of KOLs, those standing alone don't look so great, right? They're big number drops. I acknowledge that. But the key was net revenues went up, and it takes a while to calculate net revenues. So the business was expanding still, both the full service business and the platform business.
Any other questions for counsel? Thank you.
Good morning, Justice Friedman and the panel. Scott Musoff from Skadden Arps for the underwriter defendants. From the underwriter, I just want to give the perspective from the broader capital markets situation here very briefly. And as Justice Gesmer said, that you're coming into a period just as the quarter's closing. It takes several weeks to close books and do analysis. If you wait for that to occur, now you're in the middle of the next quarter. And then people are going to say you need to update that. So the SEC and the federal courts have created a regime by which you could have public offerings without having to wait for the audited and fully booked quarterly close, because we don't live in a world of continuous disclosure. We live in a world of periodic disclosure. So the standard is you pick the date under the regulations that was as of December 31st. That wasn't picked out of the blue for the number of stores. That's where this complete financial picture that you referenced, Justice Friedman, was presented. One of the factors in that complete financial picture as of December 31st were the number of stores. If you change, as Gesmer said, that one number without describing all the other ways the financials were impacted, that would be misleading in itself. So to answer Justice Kapnick's question, the standard isn't just would the investor have cared or would it have been material? The standard when you need to disclose some kind of intra-quarter or end of a quarter that isn't fully booked yet when you're doing an offering is it will significantly alter. Some courts have said extreme departure. The Second Circuit in Vivint Solar, in which we represented Vivint Solar, talks about a significant change to the company. Here, the quarter that just finished was a positive quarter. There was no significant downward departure from the performance of the company. If anything, it was a positive performance. So I would just add there are dozens of these 33 Act cases percolating through the commercial division into to this court. And if the state courts depart from Vivint Solar and the Second Circuit standard, that will create an unpredictability in the financial markets that without hyperbole could jeopardize New York's financial center and capital of the financial capital markets. Unless the court has
any other questions for any questions for counsel? Thank you. Respondent.
May it please the court. I'm Joseph Daly for the plaintiff respondent. I'd like to address two of defendant's main arguments. First, that as a matter of law, Ruhan investors would not have cared that the supposed 91 stores in its most lucrative business segment were actually just 56 stores by the time of the offering. And second, that because the defendants facially complied with the SEC's periodic reporting requirements.
But counsel, why would they care if the gross sales continued to increase? Why do they care if it's 91 stores or 56 stores if the 56 stores are supplemented by platforms and the sales continue to do well?
Because, Your Honor, first of all, as we know, that's a very fact-bound question that's actually better reserved for a fact finder as opposed to deciding as a matter of law.
So I don't understand what you're saying, that it's a fact-bound question. It's undisputed that there was an increase in revenue. It's not fact-bound. We know now, based on the undisputed record, that there was an increase in revenues despite the fact that there were fewer stores. That being true, why was that a material omission?
Right. It's also undisputed that the 91 stores was a very specific, important fact in that registration statement. I was looking over the record last night.
Why?
And at page
Counsel, why? In light of what the court said in Stadnick, we assess the materiality. The materiality of an omission must be assessed in light of the total mix of information in the public domain. Why is that information about the number of stores material?
Because they coupled that very specific number, 91, with the representation that our full service model had accounted for the vast majority of our total revenues over the past 2 and 3/4 fiscal years, 99%, 96%, and 88%.
But didn't they also say that they were transitioning?
They said that they were trying to achieve a dynamic balance between the two platform segments. I saw nothing in the registration statement talking about a specific shift from one to the other. In fact, they reassured investors in the offering, investors who, by the way, were being asked to part with $125 million of their hard-earned monies. They reassured investors that although there is this dynamic shift, this dynamic balance, we expect to continue receiving increasing revenue from the existing full service model. And that's in the record.
It did in fact do that. That's what I'm a little confused about. It did in fact increase its revenue as of the date of the IPO in the full service stores.
But Justice, Mr. Wang has shifted the focus, the snapshot of time, to what happened in the future. For purposes of 1933 Act securities liability, it is what was in the registration statement at that time. The 91 store figure was a false statement in that registration statement.
It was true as of December 2018. You're shifting the date to the date of issuance, but it's impossible for a document to be published that includes the state of the world on that date. That the way the SEC works is that there's an effective date, and the effective date here was December 31st of 2018. I don't see that your complaint alleges anything that was false as of December 31st, 2018. If there is anything that you're alleging was false as of that date, let me know what it was, because I didn't see any such allegation.
And you're correct, Your Honor, but let's not also overlook that the SEC requires specifically, it's 17 Code of Federal Regulations 230.408, requires registration statements to contain, and I'm quoting, further material information, if any, as may be necessary to make the required statements in light of the circumstances under which they are made, not misleading. And that's precisely
let me ask you a question, Mr. Daly, as to Mr. Wang said, and I think maybe in response to Judge Gesmer's question, that if they had chosen to say in their prospectus, by the way, in the course of this quarter that were just finished up yesterday, we reduced the number of stores from 91 to 56, but as you said, we got rid of the crummy ice cream and just kept the really, good selling ice creams, and we're making more money. Could they, one, have been accused of, well, why did they just pick that one item to talk about and not sort of summarize other things? And how could that have been material to your client when it isn't the most important thing to the investors to be making money? Whether you have more stores, less stores, who cares, as long as we're making money?
Two quick answers. Number one, that federal regulation that I just cited to you takes care, would be a defense that I would expect Mr. Wang to proffer if anybody accused him of selectively disclosing something. And as to the second point, the 91 stores were a very important part of that registration statement. If your honors would look in the record at page 118, you will see, and I don't know if you can see it here on the camera, you will see a full color page with their key KOLs in the center and 4 spokes coming off that KOL. And one of those spokes is the 91 self-owned online stores. Also in the record at page 199, they list those 91 stores under the heading key operating data. In the record at page 203, they list those 91 stores as key performance indicators. Those 91 stores, the fact that they formed an integral part of their most important, their most revenue-producing business segment, had nearly been halved by the time of the offering, is a gross misstatement. And Section 11, 1933 Act, Section 11, doesn't require any more than that. All we have to show is that there was a misstatement in the registration statement, liability for Ruhan.
Counsel, you keep saying misstatement, but my understanding is that this is an omission case, not a misstatement case, because it's undisputed that the amount of stores was correct at the time
as of the
referred to this. So isn't your argument really that it's an omission, that it didn't enclose its future intention that it was going to start closing stores, as opposed to a misstatement?
Yes, I misspoke. And I see my time is up here, and I would like to wind up just by noting that Congress had decided specifically that claims under the 1933 Act only had to meet the most minimal of pleading burdens, and we have at least passed that low hurdle. Thank you, Your Honors.
Thank you.
Your Honor, I just have a few brief points in rebuttal. So I think Your Honors understood this, but when I said earlier that net revenues went up in the quarter in question, I was talking about the quarter ending March 31st, 2019, the quarter the plaintiffs focused on, not a future quarter, and that's at record 390. In terms of the disclosures about the transitions, that's at record 241, 205, and 212, and they expressly state, and I quote now, that there'll be the following the following factors contributed to the slower growth of our product sales revenue as we focused more on expanding our business under the platform model. And then it goes on to say the number of our KOLs serving the full service model decreased. So there are express disclosures here about the shift to the platform model from the full service model. And that's coupled with the net revenue increase. And I think Your Honor understood this, but when I said the net revenues increase, it's not just for the overall business. It's not just because, the platform business is doing great. The platform business, the revenues, sales went up a whole bunch, but the full service revenues went up too. And those are the two lines of business. So overall revenues obviously went up as well. And we're talking about the quarter in question, March 31st of 2019.
Thank you. Go ahead.
I was going to say, unless Your Honors have any other questions, I can rest there.
Thank you. Thank you all.
Thank you.
Uruso versus NYPD.
Good morning, Your Honors. My name is Thomas Tordo. I represent the petitioner appellant. It's our position that the determination by the Police Pension Board that under Administrative Code 13-254, the board may recall members for a medical examination annually until, quote, attainment of service retirement eligibility. And after becoming eligible for service retirement eligibility, the board may no longer restore members to employment that may no longer be disabled is arbitrary and capricious. It's our position that the determination is contrary to the plain purpose and objective and meaning of 13-254. First, 254 relates to an attempt by a board, the Police Pension Board, to require a disability pensioner to submit to a medical exam for the purpose of determining whether the disability pensioner is still disabled. It has nothing to do with an application such as in this case by a police officer who contends that he's no longer disabled because he's able to work with the aid of a hearing aid.
Counsel, I have a question. I hear what you're saying, but it seems to me that under the plain language of the regulation that what they did was correct. It seems to me an unfortunate result, but I don't really understand how I cannot read the language just as they read it to preclude them from doing anything at this point.
Well, I don't see where the language in 254 supports their determination, which we contend is a rewrite of the administrative code. This is what the administrative code says in 254. Once a year, the board may require any disability pensioner under the minimum age or period for service retirement elected by him or her to undergo a medical examination.
But your client is no longer under the minimum age because of his chosen period of service. So therefore they can't act.
No, he had to, that means he had to serve 20 years.
Oh, it doesn't say
in service.
Well, it doesn't say that. It says this. I don't think it says that he had to have served them. So if he didn't have to have served them, if you just add his years of service, then he's within that category of, then he's not within the category of people for whom they can schedule an appointment.
Because Article 2 of the Police Pension Fund, we quoted in our briefs, provides that, quote, 20 years of allowable police service is required for service retirement. He only served just under 18 years. There's no way he was eligible for service retirement. And for the board to apply this statute to his situation is flipping the whole thing on its head. And therefore, we contend that the court doesn't have to defer to the Police Pension Board because their decision is contrary to the plain language of the administrative code and the facts. Mr. Russo served in city service just under 18 years when they forced him out on disability pension. He didn't work 20 years in active city service as required by Article 2 of the Police Pension Fund. He's never received benefits based on attaining a service retirement of 20 years, and he's not eligible for a service retirement. That's the real point here. And the Police Pension Board has applied a statute where they have the right to recall a disability pensioner for examination to see if they're still disabled to a situation that has nothing to do with it.
But picking up on what Justice Gesmer said in the plain language of 254A, the board may, upon his or her application, shall require any disability pensioner under the minimum age, which he doesn't meet that, right? Or period for service retirement elected by him. He doesn't meet that. That's where they have the option of sending him for an exam, and if he passes the exam, sending him back. Where in that statute does it allow them to exercise this discretion which you're advocating for under his circumstance?
No,
how old is he? How old is he?
I don't know. He's not under the minimum age.
He's not under 55. He's not under 55. And he has reached the retirement contribution period, which he elected, which was 20 years.
No, for the period of service retirement elected by him, which means that he has to have served the 20 years.
That's not what it says. Where does it say that? That he has to have served the 20 years. It says he has not reached the service retirement contribution period, not that he has served the retirement contribution period.
That would apply if they want to take away his pension.
It's really not that use. Isn't the use of the language reach significant?
No, I think it's because the board is saying you have to have attained service retirement eligibility, which he clearly hasn't. I think it's just irrelevant.
Okay. Any other questions? Any other questions for Mr. Tordo? You have time in response. Let's hear from the respondent.
Good morning, Your Honors. May it please the court. Jonathan Popolo for respondents. I think the justices have basically laid out our argument as we did in our brief, that the plain language is clear, that the board's authority is circumscribed to situations where the disability pensioner is still under the minimum period for service retirement that person elected. And that's not the case here. The person elected a 20-year minimum period for service.
You've got to be either less than 55 or not have reached from your date of commencing service the 20 or 25-year period that you selected to be your retirement period.
Correct. I mean, I think it depends on which one you elected
Right.
at the time you joined. And if that wasn't the case, then you
Had he
could.
joined the 25-year period, it would have given him another 5 years, but he joined the 20-year period.
Correct, Your Honor. And that's not in dispute. If this wasn't the case, then you could have a situation where someone's past that 20-year period, and the board could constantly keep recalling them until they're in their 60s or 70s to potentially see if they're capable of working at a different job, and that's clearly not what the statute contemplates. And the language could not be plainer in this case. I mean, the board's decision was entirely rational.
Any other questions for counsel? Mr. Tordo?
Yes, just to reemphasize, we say that the administrative code provision in question applies when the board seeks to require the disability pensioner to be subjected to a medical exam. It doesn't apply when the disability pensioner says, I'm not disabled and I want to work. And that's what we say is the arbitrary and capricious nature of this.
Say that. Where does it say that? I didn't see that in the regulation.
Yes, it says once each year, the board may, and upon his or her application, shall require that's his or her application for disability benefits. Not to go back to work because you're not disabled. Once a year, the board may, upon his or her application, require any disability pensioner under the minimum age or period for service retirement, elected by him or her, to undergo a medical examination. It doesn't say that if you apply to be reinstated because you're no longer disabled, you don't want to be a disability pensioner, they can't process your application. So we request that the determination be annulled and that the board be directed to process his application on the merits.
Any other questions? Thank you both. People versus LaFontaine.
Yes, good morning, Your Honors. Danielle Krumholtz for Appellant Luders LaFontaine. Would I be able to have 30 seconds for rebuttal?
Yes.
Thank you. Your Honors,
we'll make it a minute.
Okay, thank you. This appeal should be held in abeyance and the court should remit for a prejudice hearing because Mr. LaFontaine received affirmative on-the-record misadvice about the immigration consequences of his guilty plea. Under the long line of cases regarding immigration consequences misadvice under Padilla, this court has repeatedly held that defense counsel's representations.
Counsel, I have a question. Why isn't this case controlled by Gomez, which, as you probably know, I dissented in? But having dissented in it, I, like everybody else, am bound by our decision in that, and I can't see any light between this case and Gomez, and it seems to me it requires that we affirm.
Yes, Your Honor.
Well, I may not like the result. It seems to me that's what our jurisprudence requires.
Well, Your Honor, I would first note that Gomez did not overrule the 7 prior cases that the First Department issued between 2016.
But factually, there was a factual distinction was made by the majority in that case, and it seems to me the same facts are that the facts here are very similar to what was there.
Well, I apologize. I believe that Gomez is actually very distinguishable from this case. In Gomez, the court found that counsel's remarks, which were that he spoke to his client regarding all possible consequences and that he had, quote, looked into everything, were general in nature and therefore could be considered potentially accurate and potentially inaccurate immigration advice. So they required an evidentiary hearing via 440. In this case, it was very succinct and very clear that counsel was endorsing the court's statements regarding the potential negative immigration consequences. And in this court's prior cases, particularly People v. Pecaro, that's exactly what defense counsel said. It was the same statement of advising of the potential immigration consequences, period. So unlike Gomez, here it's very clear that counsel did not advise and incorrectly advised that there were only potential consequences and not mandatory consequences, as is required under this court, under Padilla.
Any further questions for counsel? Thank you. Respondent.
Good afternoon, Michael Yetter for the People. Defendant's Padilla claim must be rejected because he has failed to irrefutably establish that his attorney, one, affirmatively misadvised him about the immigration consequences of the plea on the record, and two, proved prejudice. And we believe that under the Court of Appeals precedent and the court's recent decision in Gomez, the judgment must be affirmed for those reasons. Unless the court has any questions for the reasons stated in our brief, we'd ask for you to affirm.
Thank you.
Thank you.
Ms. Kremholz?
Thank you. First, just regarding the people's contention regarding prejudice, this line of cases has held that once affirmative misadvice is established on the record, the case is remitted for a prejudice hearing. So there's no need for a discussion about whether or not Mr. LaFontaine can prove prejudice. We have argued in our briefs that he can, simply based on the record. It's clear of his strong ties to this country, including U.S. citizen children and how long he's been here as a green card holder. However, that's not what this court needs to decide, whether or not he can prove prejudice. The issue here is simply that there was affirmative misadvice on the record that trumps any potential off-the-record conversation that may or may not have happened between counsel and Mr. LaFontaine. And under this court's long line of cases, that is affirmative misadvice, and that is enough for this court to hold the appeal in abeyance, remit for a prejudice hearing, and at that hearing, it is our burden to then prove that Mr. LaFontaine was prejudiced and that had he been properly advised of the mandatory consequences, he would have proceeded to trial instead. And that
it seems to me that factually, this case is less favorable for the defendant than Gomez. I suppose, I don't know whether Gomez is going up on appeal to the Court of Appeals or not, but I don't see how you get out of Gomez. Any other questions for counsel? Thank you. Thank you both.
Thank you.
Lipson versus Herman.
Good morning, Your Honor. Thank you. John Golashevsky on behalf of the appellants, and may it please the court. Your Honor, this case hinges on two questions. First, did the entity Taylor Stewart Herman Incorporated exist in 2017 when it repeatedly contracted with the respondent and was paid $650,000 pursuant to those contracts? And the answer to this question is obvious. The record developed at the arbitration is replete with evidence of contracts and building permits and bank records and insurance policies which support the existence of this entity and which has never been challenged by the respondent. The second question is whether, in light of this mountain of evidence developed,
that was a factual determination by the arbitrator, was it not? Whether Taylor Stewart Herman Inc. is the same as Taylor Stewart Inc. And he made the factual determination that they're not. And how in an arbitration do we set that aside?
I'm sorry, Your Honor, that's not what the arbitrator concluded. What the arbitrator concluded, and I will quote, "No other entity other than Taylor Stewart Herman, the individual, existed or contracted with the claimant." This is not saying that Taylor Stewart Herman Inc. is the same as Taylor Stewart Inc. It is a completely different statement.
Yeah, because he found that the fact that you put a corporate name on Taylor Stewart Inc. for a non-existent corporation meant there was no other entity contracting. A non-existent entity can contract with the petitioner.
But Your Honor, the question is not whether Taylor Stewart Inc. existed, and there is the Harmon case and the various other cases which we could show that a Scrivener's error wouldn't matter. What the arbitrator said is very clear.
What did you do to show that it was a Scrivener's error?
Well, Your Honor, to be clear, the issue never came up at trial, at arbitration. The issue was in the arbitration award, where for the first time the arbitrator made this irrational holding that no individual, no entity other than Taylor Stewart Herman, the individual, existed.
Okay, counsel, let me ask you a question.
Sure.
It seemed that there were a lot of that Mr. Herman himself actually used Taylor Stewart Inc. many times, that his email address was Taylor Stewart Inc., that there were other documents saved by that. So even though it seemed to have no bank account, it's hard to say that it's a Scrivener's error because he used it all the time. That was just something that he was doing. And that's why to say that he never used it, it was just a one-time Scrivener's error, I think does not comport with the evidence as I read it. Or as
be
the
clear,
arbitrator saw it.
I'm sorry. To be clear, he did use it as an email address. But let's be very clear. Had the arbitrator said the first two contracts of the fixed price contract were with Taylor Stewart Herman Inc., and the third was with Taylor Stewart Inc., let's say he said that, then that might be an interesting question, and maybe there could be a mistake of fact. But that is not what was. I'm sorry, please.
I'm sorry, but it's true that the third one was Taylor Stewart Inc. and that was drafted by his lawyers, and he signed it.
Well, to be clear, Your Honor, that's fine, and let's put that aside. The first two contracts and all payments were made to Taylor. Your Honor, we can, Your Honor, with respect.
Because that's the critical contract, and
no, I'm sorry, Your Honor, I don't believe it's the critical contract. These are all part of a one fixed price contract. What the arbitrator said is that no entity other than Taylor Stewart Herman, the individual, existed. We know that to be patently false. Taylor Stewart Herman Incorporated was a duly formed corporation that entered into contracts, that was on the building permit, that was on the insurance, that received all monies, Your Honor. The fact that Taylor, I'm sorry.
Why you're ignoring the fact that in the third contract, which was the big money contract, that the signatory was not Taylor Stewart Herman Inc., but Taylor Stewart Inc., which does not exist.
Well, Your Honor, and if the arbitrator had said the third contract is different than the first two, that would be different. That's not what the arbitrator said. The arbitrator said it's a non-existent corporate entity and no entity contracted except for Taylor Stewart, the individual.
Did you offer anything to show that, in fact, it existed? I mean, didn't you say there was no bank account? And it was not registered. It didn't exist. I mean, what did you show the arbitrator to show that Taylor Stewart Inc. existed?
Your Honor, that's not the question. The question is not whether Taylor Stewart Inc. existed. The question is whether Taylor Stewart Herman Incorporated existed. That's the question.
But that's not the same as Taylor Stewart Inc.
Oh, Your Honor, I absolutely agree, but that's the issue. The issue here is that the arbitrator did not say that he used the fictitious.
Why is that the issue? When Taylor Stewart Herman Inc. is not the entity which signed the contract.
Of course, Your Honor, of course it is. Of course it is, Your Honor. This is a three-part fixed price contract. Of course Taylor Stewart Herman Inc. signed the contract.
Whose name appears on the first contract, the design contract?
Taylor Stewart Herman Inc.
And on the addendum?
Taylor Stewart Herman Inc.
And on this contract?
And the third part of it, it says Taylor Stewart Inc. Okay, again, Your Honor, had the arbitrator said there is a problem because the third contract is different.
Now you're saying it's a Scrivener's error.
Well, no? Your Honor, we came in after the fact and we said, well, of course it's a Scrivener's error. There was no meeting of the minds that anybody would change entities. By that time, more than $100,000 had been paid by Mr. Lipson to Taylor Stewart Herman Inc. Do you think that everyone just woke up and decided to change entities upon who the payments were going to? Moreover, after the third contract is signed, all payments, $500,000, are paid to Taylor Stewart Herman Inc. It is against the backdrop of this information that the court has to look at the arbitrator's holding that says no entity other than Taylor Stewart Herman, the individual, existed. That is grossly irrational. There is no justification for it. And indeed, given the opportunity in his award and on a motion for modification, never did he explain it. And the Spear-Leeds case says that A, we do not countenance irrational awards. B, when the arbitrator refuses to provide justification, and here there is no justification for it, that the court can take that into account.
Any other questions for counsel? Thank you. Thank you both. This concludes oral arguments for today. Court is adjourned.